Thank you. But yes, so we're the Community Sector Council. We support community groups across the province. And, we're really excited to have an initiative called SETA, which is Social Entrepreneurship Through Acquisition, where we help folks in the community sector buy businesses. And so very excited to have our special guests here, Michael and Atanu from Cox and Palmer, who can give us kind of the legal perspective of buying a business. And so with that, I think I'll just pass it over to you both. If folks have questions through the session, feel free to drop them in the chat, and maybe if that works for you both, we can field those at the end.
Yep, that sounds good. Appreciate the introduction, Andre. Like Andre said, my name's Michael Hrabowsky, and I'm here with Atanu Halder. And we're both lawyers at Cox and Palmer. Atnu's practice focuses on corporate transactions. So a lot of information is going to be pertinent to the attendees here today. And my practice incorporates a lot of corporate governance and managing your business after you've acquired one. We've got a presentation done and we're going to go through that. And I'm just going to say that I think where I'm sharing my screen, Atnu, when you're ready to go to the next slide, just let me know. I don't know if you have control over that. But I guess we'll get into it. All right. So, and just generally, this is for information purposes. This is not legal advice. Happy to follow up with any of you afterwards. We'll have our contact information there at the end, and we're excited to be working with Community Sector Council NL on this initiative that they have going.
Okay, perfect. Thanks, Mike. So just as an overview for today's presentation, I'm going to start with the aspects of purchasing a business. So we're going to break down the difference between an asset purchase, a share purchase, the overview of a purchase agreement, which underpins either an asset purchase or a share purchase, and then finish off that section with a little coverage of due diligence, with a focus on what you should be looking for when conducting due diligence and typical clearance and searches that we usually order during that process, just to get you familiar with our protocols for closing a transaction. And then Michael's going to take care of the basics of business associations after you've acquired the business, what different aspects of what different business associations exist, and whether incorporation is the right type for you. So we're going to start with purchasing the business. The basics of a purchase agreement, as basic as it gets, is really who are the parties, the purchaser, who's the vendor, what assets are going to be purchased. So either is it going to be personal property, is it going to be real property or land, what the purchase price is going to be, how much money is going to be paid for those assets, will it be paid immediately up front or over time, and then also when will the transaction close? So what will be the effective date of purchase? As I stated at the beginning, there's two really main types of acquisitions. There's an asset purchase and share purchase. You can go to the next page. So with the asset purchase, you're picking specific assets of a business and you're purchasing them. And really, there's two types of assets. There's tangible assets or intangible assets. So when we refer to tangible assets, this means physical assets such as vehicle, equipment, land, other things like that. Physical assets that you can actually touch. The other type of asset is intangible assets. So a lot of times in asset purchase or share purchases of a business, intangible assets will be a big part of that purchase because you're purchasing the goodwill of the business. So there's a valuation attributed to that. There's also intellectual property rights. Let's just say you have copyright over non-physical media. Customer lists. These are all intangible assets that have value and can be structured in a purchase agreement to be purchased. You can move on. So just as a little breakdown, we're going to do some pros and some cons of the asset purchase from both the buyer and seller's perspective. Pros of an pros of an asset purchase from the buyer's perspective is it's selective acquisition. So you can pick the assets you want and you can leave behind the assets that are troublesome. So obviously, when operating a business, there'll be revenue coming in, but there'll also be liabilities. So instead of taking all of that on as the buyer, you can hopefully negotiate a point with the vendor or the seller and just pick the assets that you want, the equipment or maybe the customer lists, and you can leave everything else behind, which is very nice from the buyer's perspective. The pros from of the asset purchase from the seller's perspective is that if they want, they can continue on their business. They don't have to just walk away from everything. If they have certain equipment that they don't need to use anymore, or outdated equipment, or they have land that they want to realize on and get rid of, they can do that, and they can do it through the selective process, which is really nice, especially if the seller wants to continue on with their business. And they can also pick the price of those assets to be sold. So there's no actual valuation that goes into it if the seller chooses not to. You can move on to the next slide. The cons of the asset purchase, and this is kind of applicable to both parties, is that depending on what you're purchasing, it can be very complicated, because an asset purchase can be as simple as just purchasing one piece of land, or it could be one piece of equipment. But if you're actually purchasing a business through an asset purchase, it can be troublesome sometimes in terms of picking out all the assets that you need, running the due diligence to ensure that you have all the assets that you have are proper. You also need to negotiate the prices for these assets, and a lot of times this has to be done on an individual basis. And the seller has to get this information to you. So this is troublesome on their part, because they have to go through and run inventory and make sure that all the information is disclosed. So oftentimes it's a lot longer of a process, and it takes a lot more legal work to make sure that everything is good and ready and properly accounted for. We can move on. From the share purchase, so Michael's going to touch on this a little bit in his section, where he's going to break down a corporation and what it is. But as a slight preview, I think someone just joined. As a slight preview, a business is a legal entity, so it's incorporated under legislation. The owners of a business are their shareholders. So they control the corporation, and the corporation has its own assets and liabilities. But the shareholders are the ones who control it. And during a share purchase, a buyer will buy the shares directly from the seller. So they'll give them the shares, and they will walk into the corporation as the sole owner. We can go to the next slide. So yeah, oftentimes all the shares are sold if a seller is selling their business. Usually they don't stick around. They can stick around in other capacities as an employee of the corporation, or as an officer. But for the most part, the ownership of the corporation goes to the buyer, because they're the sole shareholder now. And obviously, the pros of the share purchase from the buyer's perspective is now that they own everything. They step right into it. And you don't own these assets personally. So there's a bit of protection between the shareholder and the corporation, because the corporation holds all the assets and the liabilities, and you are just a shareholder controlling the corporation and driving the business forward. Obviously, the assets are protected with the corporation, so you can't just use the corporation's assets for personal use. It has to be for a business use, obviously. But it's just a lot cleaner in terms of just stepping in and owning the corporation outright and the business. The cons from the buyer's perspective, again, is kind of a double-edged sword because obviously you step in as shareholder and you take control of the corporation. Obviously, there could be liabilities, unlike with the asset purchase where you can pick and choose. But again, at the end of the day, you can also negotiate these points with the seller. You can make it a condition of your agreement that you won't buy the shares unless they get specific encumbrances or liabilities dealt with before closing. If they don't do it, then you're free to walk away and not purchase the shares. Sometimes you're in a position to do so. Sometimes the seller might not want to do that. So it really depends on the negotiations and what you're able to leverage. But again, this can be a con because sometimes you might be stuck with liabilities if you really want the business. And it just really depends on the situation. We can move on. So the pros of a share purchase, again, from the seller's perspective, much simpler. And I guess something we should touch on is the lifetime capital gains exemption. So as a seller, if you sell capital property, certain capital property, when it appreciates, you have to pay what's called a capital gains tax. So that means, just say something appreciates by $20. You bought something for $1, it's now worth 20. You sell it for 19. You sell it for 20. Sorry. There's an appreciation of $19 between what you paid and what you got. In Canada, capital gains tax would be 50% of that 19 is taxed at your highest marginal rate on the individual basis. With the lifetime capital gains exemption, specific times when you sell your shares of a business, you can use this exemption to deduct the capital gains that you gain from the sale of the shares, and you can deduct it from this limit, so you don't actually pay tax on that amount. And whatever the limit is reduced by, if there's any amount left over, let's just say you sold your shares for $250,000, you wouldn't pay tax on it. There would be $1 million left. And if you started a new business and sold it, and it qualified under this exemption, then you could use that deduction limit on another share deal down the road. To qualify, you have to be a small business that's incorporated. It's what we call a CCPC. So it's a Canadian-controlled private corporation, which means that the shareholders have to be Canadian residents. You have to make a certain amount of revenue, or it has to be within a certain amount of revenue. And you have to hold shares for a specific amount of times before you sell it. If you qualify, you can use this lifetime capital gains exemption on the sale. But obviously, I would advise before you structure a deal or before you think you can avail of this, obviously consult a tax lawyer or a chartered accountant who can better instruct you on whether you've hit that limit. Cons of a share purchase from the seller's perspective, again, you no longer have, most times it's an outright sale. You don't retain any shares in the corporation, so you no longer have legal control of the business and you walk away. Sometimes that's good. People want a fresh start and they just want to get away from it all. Other times people might not want to structure it that way. So it just, again, really depends on what the parties are looking for and what they're hoping to accomplish. We can go to the next slide. So now this is a further breakdown of a purchase agreement. I just wanted to go through the main divisions of an agreement. So when you come to a lawyer and you have them draft, whether that's an asset purchase or a share purchase agreement, it's usually broken down into these categories in the agreement. Again, it will depend on what you're buying, the purchase price, and how familiar you are with the asset itself. So sometimes all of this is not necessary, but a typical business transaction, whether that's asset or shares, will be broken down into these categories. And I'll start with the first. So the recitals usually sets out who the parties are, the purchaser, the vendor, in an asset purchase. In the share purchase, it will often list the corporation as well, the corporation that shares will be sold for. And sometimes we'll also list the types of shares that are being sold. Interpretation, that will set out the defined terms that will be used in the agreement. Then we'll go to purchase and sale, which will list out the purchase price, how the purchase price will be paid, when the purchase price will be made, and other tax considerations that might need to be applicable to the purchase and sale. To the fact that they own the asset, that the asset is unencumbered, that they have the authority to sell the asset, and that they're legally authorized to enter into this agreement. So that gives the buyer comfort that they are purchasing from someone who actually owns the asset, and that there's no liabilities or hidden liabilities attached to it. So in the off chance that there are things that exist that weren't disclosed, the buyer has comfort and can go after the seller and say, hey, I only bought this on the basis that you gave me a rep and warranty that this asset was in this condition, or these liabilities didn't exist. And that also exists from the seller's perspective too. It gives them comfort that the buyer has the authority to actually enter into this agreement and purchase as an actual buyer. The next section is covenants or conditions. These are advantageous from the buyer's perspective as well, so that they can put in conditions saying, hey, listen, we've negotiated and we need these liabilities to be lifted before we buy the asset. And if you don't do this by closing, then we can just walk away from the deal altogether. And that's it. So that gives them comfort that the seller, they won't be tied to buying something that's completely useless to them if all these liabilities exist. And also another important one is financing. So obviously a lot of times purchasers need financing to buy these assets. So they'll make it a condition of closing that they need to get financing before they enter into this deal. If they can't get financing by a certain date, then the agreement just goes away and both parties can walk away. The last one is closing deliverables. These are, again, from the legal perspective, certain things that we require from both parties. Counsel will require these items. They're pretty typical. But again, these are just from the legal perspective, things that need to be exchanged between the parties in order to close the transaction and finish the sale. We can go on to the next one.
All right. Hey, Atanu, can I get you to re-enable your video? Just because I turned it off when I brute forced the settings. There we go. You're back. Thanks.
Okay, perfect.
Okay, here we go. Yeah, working now.
Perfect. Sorry. We touched on purchase price earlier. But I wanted to just outline again, payment of the purchase price can be structured in many different ways. This specific one is called a vendor take back. So oftentimes, from the simplest form, a buyer might not always have the purchase price ready at the time of closing. So what often happens is that, let's just say the business is going to be bought for $1 million. What will happen is a portion of that purchase price will be paid in cash on closing. Let's just say $500,000, and then the rest of it will be payable by a promissory note. So what a promissory note is exactly what it sounds like. It's just a promise to pay the amount at a later time. So the buyer will sign this note and say, hey, the money will be paid at this date in the future. Oftentimes this is negotiated between the parties. The vendor can ask for interest to be paid at a certain point, but it will set out the details of when the payment will be made and whether it will be paid in installments over time. So again, it's just deferring a part of the purchase price to a later date. In this case, a vendor take back is one step further to that. So not only will they provide a promissory note to pay, but the vendor wants more comfort in the situation that they will actually fulfill their promise to pay that based on the note. So what they do is they often secure the note by taking a take back interest in the asset that they sold. So the easiest way to, probably the easiest example, and I think there's an example on the next page if we want to just go to that. So there's a purchase price for the asset. It's $1 million. The closing payment is $500,000, as we discussed. The remaining payment, the buyer is going to execute a promissory note for $500,000 on terms acceptable to the seller. And then the seller will ask for, so say the asset was land. They bought a piece of property from the seller. To secure the payment of the remaining $500,000 of the note, the seller will require a primary first interest mortgage, first charge mortgage over the property they just sold to the purchaser. So they sold it, but they said, hey, we're taking a first charge mortgage over that property based on the note that you provided. So what that means is If you pay the note, there's no issues. The mortgage goes away and it's discharged sometime in the future after the full payment is made. However, if the buyer messes up and doesn't pay their obligations when due under the note, then the seller will have the ability to enforce on their mortgage and step in, take the property back, and sell it to recoup the loss that they had from the note. So obviously, you never want it to get to a situation like that. But again, it just gives comfort to the seller that the buyer will actually come through, and it also incentivizes the buyer to make good on their promise to pay back that amount of money.
Adds a bit of flexibility too for the purchaser if they can't come up with the full financing amount for what the business is. Just like Atanu said, just be aware of the conditions of whatever you're getting into, the promissory note, the terms of it. But it's just another way to kind of structure an acquisition.
Yeah. So the last little section that I just wanted to finish on before I turn it over is due diligence. So obviously, before you acquire a business, you have to ensure that you run the proper due diligence, and you understand the business or the assets that you're buying of the business. And this really comes down to the financials, the liabilities, the state of the assets, and whether there's any encumbrances that exist, and also regulatory considerations. I mean, if you're buying, let's just say, for example, you're buying a restaurant or a food business, you need to ensure that that business has proper food establishment licenses issued, or that you can at least get a food establishment license to run the business after you've acquired it. If you're buying a campground, you need a tourism license. It's just there's regulatory concerns that you need to make sure that you have checked, and to ensure that there's nothing stopping the deal from going through for that basis. And again, the typical clearance and searches. So from the lawyer's perspective, when we're structuring these deals and we're drafting these agreements, we'll often run these typical clearances and searches to ensure that there's no outstanding liabilities that are owing to government departments, whether that's federal or provincial. And these are the typical searches that we list. And these are pretty much important just for the fact that we want to ensure that if there's an amount owing, they often form liens on the property of the person who owes those obligations. So if the seller has a bunch of liens against it from these departments, that can affect the property that you're purchasing. So you always need a lawyer to run these searches on your behalf to make sure that you're not buying something that's already been liened, because a lot of times in that case, if these are pre-existing liens, if you purchase those assets and there's an existing lien, the department has the authority to come in and take that property from you, whether you paid you paid it outright and you did everything you were supposed to do. They can still come in and enforce on your property on that basis, because they had a first charge lien over the asset that was sold. So obviously, always consult with a lawyer and make sure that these searches are run, so you're not left with a defective asset.
All right. So that covers, at least at a high level, the acquisition process, the transactional piece of it. So I guess when you're from a purchaser standpoint, if you're looking to acquire a business, are you going to incorporate? Are you going to operate as a sole proprietorship, a partnership, a joint venture? For the purposes of this presentation, we're going to focus on incorporation. It seems like the most well-suited for most people and most business ventures, because it gives a layer of protection from personal liability. It gives you what's known at law as the corporate veil, meaning that you can't pierce the incorporation to find the owners or the shareholders or the members personally liable for most things. Certain liability attaches to directors, in certain circumstances, which we can touch on later. But jumping into incorporation, So incorporations are considered legal persons. They have to file their income, they have to file their tax returns, pay taxes. You're entitled to enter into contracts and create debt, deal with the public, deal with lenders as the corporation, separating yourself personally or the group of shareholders personally from those transactions. You can choose to be limited, corp, incorporated. There's plenty of suffixes. That's just a small point on it. So there are in an incorporated company, there are shareholders. Shareholders are the owners of the corporation. They elect the directors, and the directors hire officers. So these are essentially the players that are going to manage and operate the corporation. Um, so there must be consideration for the shares. What that consideration is, how much that is, it's really up to you. If you have people coming in for a higher amount and they want more shares in the corporation, more control in the corporation, that's really up to you and the people that you're incorporating with. And so you can issue multiple classes of shares when you do this. Each of those classes of shares can have certain rights attached to them and privileges. They don't all have to be equal. And this is just talking about a standard incorporation. We'll touch on not-for-profit incorporation and cooperatives because they differ in some aspects. But generally, you want to, with this, your shareholders get together, especially when you only have a couple at the beginning or a few in general. You want to have a shareholder agreement, which we're going to go to next. But this is going to outline the rights and obligations of the shareholders and the restrictions that are generally attached to the shareholders, not just the classes of shares. So shareholders agreements, this is a big thing that I like to see all corporations have from the outset. I've seen a lot of people incorporate businesses. They have partners. They have some initial shareholders. They don't take the time to get a proper shareholder agreement put together. It doesn't have to be anything fancy. It can be a standard form agreement, but you want it to cover as much as possible, to contemplate as much as possible, because at the end of the day, they're unanimous agreements. So if you take on more shareholders down the line and then you want to make changes or amendments to it, you need to get the approval of all the shareholders. So you want to make sure that the way it's set up is right for the initial people incorporating the business and acquiring the initial shares. And just kind of it's a forward-thinking document that you can have done up. And these are just a few of the things that go into them in general. So one of them being how shares can be transferred. You have shareholders come in, they obviously are purchasing shares. You've vetted them or you've wanted them to have shares for a certain reason, and you don't want the ability for them to be able to transfer those shares to somebody else or another corporation without having contemplated what constitutes a permitted transfer. And dispute resolution mechanisms. These are important because a lot of things you don't want to have your first step to be to take something to court. You want there to be a negotiation period and some sort of escalation clauses, whether it goes to mediation or arbitration, before it has to go to court. That's just a more reasonable way to deal with disputes. But if you don't have it in there, then the right to go to court is there, and it can be expensive, time consuming. It can have implications for your business. Court actions are all public record, so any searches that come up from potential partners are going to flag those things. And then obviously rights of first refusal and maybe a little bit more applicable to most people is what's known as shotgun clauses. So if you and one other person or just a couple people are in a business, but you all have equal ownership of the business, it's really hard if there's a difference of how that business should grow or what opportunities it should take down the line to resolve those. And sometimes it's better just for one shareholder to have the ability to buy out the other shareholders. It's kind of like you have two brothers and there's a cake and one gets to cut it and one gets to pick their side or what piece they want. So you try to make that offer as fair as possible, because essentially if they don't, if you try to buy somebody's shares for $1 and they're worth $100,000 and they say no, they have the opportunity to buy your shares for that price. So it's just a simple mechanism to put in there that's right for a lot of smaller or incorporations with smaller number of shareholders. The directors, they're elected, like I said, by the shareholders to manage and supervise the corporation. They owe the corporation a duty of loyalty and a duty of care. They're protected for the most part by the corporate veil, so the actions that they take are they themselves are protected from liability. But there are certain things that directors or certain actions that directors take that can attach personal liability as well, and mainly tax decisions that they make. Officers, they're hired by the directors. You want to maybe assign a president, a treasurer, a secretary, people to run certain aspects of the corporation and be responsible for managing certain aspects of the corporation. And that's just a good hierarchy to have and a good division of labor and management to have. It gives clarity to who's responsible for those things and making sure the corporation's moving forward on those issues. So again, the pros of incorporation this is over sole proprietorships and partnerships, and this is the limited liability status. It's paramount to a lot of people, to most businesses and people looking to incorporate and acquire businesses and run businesses, because at the end of the day, you want to have that separation in terms of liability. As an incorporation, you have the ability to attract capital. A lot of people, you can issue shares out in the corporation. Depending on how big you want the corporation to be or what your goals are, you can take on investment for smaller portions of it. You can take on strategic partners and people who have a larger vision, I guess, for the corporation that may be able to fund it financially, that interests you. So again, I guess I'm getting kind of ahead of myself on some of this stuff, but the limited liability is the big pro in incorporation. Shareholders can't be held personally liable for the debts and obligation of the corporation, save for any personal guarantees that you end up signing in your own capacity to guarantee the debts and obligations of the corporation. Sometimes, obviously, if you're taking on or you're borrowing large amounts of capital, then lenders are going to require certain guarantees from principals and from shareholders. But in general, for what you'll be dealing with by and large, you're not going to be liable for the debts and obligations of the corporation. You have tax advantages as an incorporated entity as well. You have lower tax rates. Again, the small business deduction, which Atanu kind of mentioned with the CCPC, being the Canadian Controlled Private Corporation. And you have more flexibility in your tax planning. Again, when it comes to taxation advice, myself and Atanu don't work specifically in the tax planning aspect of law, but we have plenty of lawyers here that do, and generally on any transaction that requires tax advice, we have somebody that you're able to talk to and get the correct advice for. So there are some cons to incorporation. Rather than just be able to set up as an individual and operate a sole proprietorship, you have to go through the process of incorporating. You have to maintain the corporation, so you're filing your annual returns. If you make changes to the structure of your corporation, they might require filing fees as well. Generally, they're not overly onerous, but it is a consideration. There can be restrictions on the use of corporate assets. Again, you're not just a single or a sole person operating a business, using it for purposes X, Y, and Z. They're generally attached to the corporate purpose, however you're using those assets. Getting money or profits out of the corporation, you have the flexibility of declaring dividends. If it's just a standard incorporated company and there's profits and there's mechanisms for distributing those profits to the owners. There's ways to get money out of the corporation, but again, it's not as simple as being a sole proprietor with a bank account that is, your business account as well, and you having complete control over it. And it's obviously governed by legislation, the Newfoundland Business Corporations Act. And if you're incorporating in Newfoundland, each province has their own specific legislation, but also you can incorporate federally. I'm not sure, if that's necessarily has the same value for some more bigger corporations, but it's governed by the Canadian Business Corporations Act. So they're all pretty similar. They have the same requirements by and large, but there's specific provisions, and you're going to want to make sure that everything's being filed correctly and pursuant to the correct legislation. Because if one thing registries love is to reject things for technicalities, so you want to make sure that you're filing correctly. Nonprofit organizations, these are organizations that operate for purposes other than just generating profit. They often have a mission statement, and they're driven by that. You reinvest those profits that you make, whatever the revenue the corporation takes, back into the organization. And because you're doing that and you're not taking money out of it as members or shareholders, then you enjoy the tax exempt status. These are generally or just common examples, I guess, are educational institutions, cultural organizations, advocacy groups, things geared towards those areas. Charitable organizations, they specifically operate for charitable purposes. Some examples of those are, poverty relief, advancement of education, religion. They can be social welfare, civic improvement, recreation. You have to register as a charitable organization and apply for the tax exempt status that comes along with that. But if it's, it's again situation specific and what the objective of this corporation that you're using or creating is, and if it applies to you, there's certain benefits that attach to that as well. We know that there's, or we've had some, I guess, general feedback that, operating a cooperative or acquiring a business as a cooperative is a favorable way to go. I think it's a good way for a small group of people that are looking to buy a business to proceed, because you still have to incorporate, but you're owned and operated by the group of individuals for a mutual benefit. You still want to create bylaws on how things are run and managed, but essentially, typically, it's member owned and democratically controlled. So one member, one vote. And you come to unanimous decisions or majority decisions in that capacity. Whereas typically with an incorporation, somebody is going to have a large voting control or a large enough voting control to make decisions. And it's less of a democratic, it's less typically a democratic way of coming to decisions and decision making. And you can focus the objective of why you form the cooperative on focusing on the community and the needs of the members. You don't have to reinvest all of your revenue and profits back into the corporation in the same way that you do for nonprofit organizations. But you typically do reinvest most of it back into the organization, subject to any provisions that you've created in your bylaws for distribution of profits. But again, everybody's voting on those things, so it's not one person saying that, I think we should distribute these profits to the members. We put in a lot of work. There's this money sitting there. Generally, the goal of creating the cooperative and running the business means that there's a bigger picture, and that money's supposed to go back into the business. So just a little bit on the incorporation process itself. So you can register federally or provincially. You identify in your articles of incorporation your number of directors, your minimum and maximum, your registered office. You have to have one. If you're in Newfoundland, you have to have a registered office here. You file your notice of directors to say who those directors are, because all of this is essentially needs to be available to somebody who's going to look into the business. Generally, it's not just you can search on Google and say this is the name of the corporation and get those things, but if you're coming to do any due diligence on a business, then we would have the ability to look into who those directors are, where the registered office is, are they in good standing with the provincial registry or the federal registry? Have they filed their annual returns? Kind of due diligence. If you're looking into purchasing a business, you want to know these things going into it. Again, kind of going back to the liabilities that you're looking at a business that they might have. Corporate organization, we talked about the unanimous shareholders agreement. The minute book, this is just kind of a log of everything that you do within your corporation. If you're, it'll have your articles in there. It generally starts with those, all your constating documents. If you make changes to your share classes, if you do share splits, if you issue stock option plans or anything like this is just a way of organizing it and keeping everything in good order, in case somebody is doing their own due diligence on your business and you want to kind of show them, what's gone on in the business and where it stands. So it's generally we'll set up a minute book if we're working with a corporation, just to make sure that everything that they do going forward is well documented and organized. And then again, maintaining good standing in the registry, filing your annual returns. Generally, we offer, obviously, to any corporation that we're helping to incorporate, and certainly any corporate clients that if they want us to kind of handle their annual returns and stuff, then we can jump in and make sure those get filed on time. So liability of corporations can be limited by whatever contracts the corporation's entering. They're limited to the parties with whom you're contracting because you have to have privity of contract to have that liability attach. And then obviously damages stemming from the contract are generally defined in there, what those damages contemplate. You do have, as a corporation, statutory liability. So you're liable for taxes if you're delivering a product to a consumer. Excuse me, you have consumer product liability. There's legislation for these different liabilities as well that kind of defines how they attach in specific situations. You also have liability to members of the public for environmental actions, negligence. Source again is legislation. It's all guided by acts, and it's not limited to a dollar amount as in contract might be. So in contract, you may just specifically have a cap on damages to whatever the value of the contract is. But statutory liability can go well beyond whatever you might have in your head. If you're an employer, then you have and you're going to have employees, then there's certain things that you need to have. You have to register with Workplace Health and Safety. You have to understand your basic human resources and human rights issues, including any labor laws, especially if you're having employment agreements and contracts. You want to contemplate what their rights might be on termination, what obligations survive termination that they might have in terms of confidentiality and solicitation provisions. And you want to account for those because if you don't have that, the common law can be pretty generous for long-term employees that are ultimately terminated. And you have to understand your obligations, including remittances and payroll to the CRA, because they never forget those. Again, so if directors are not acting in good faith, or the corporations failed to make remittances to the CRA, it's possible that liability might attach to those directors themselves because they're in charge of managing those things and ensuring that they're done correctly. So it's not to say that in a corporation you're completely devoid of liability that might attach personally, but it's usually role specific and directors are one of those roles that might have some liability. So I went through that kind of quickly, but I wanted to leave some time at the end for some questions. Again, this is this is our contact information. So if anybody wants to reach out, I mean, like I said, we're excited to work with CSCNL on this program that they're running, the SETA initiative. So we're happy to kind of jump in if anybody does have any questions. I'm going to just switch to this slide. If anybody didn't take down the emails and they want to grab those, they absolutely can. They're on the website as well. And I would imagine a lot of the questions that people are going to have are specific to the situations that they're in. So we're kind of happy to, understand that a little bit better and then help you come to whatever answer you need on that. And if it's that you're at a stage of a transaction and you need, assistance getting into the finish line, there are certain things that you're going to want to make sure you have and have organized properly. And that's a big part of why I think this initiative is good in connecting you all with, a law firm that's well versed in it. So I guess we'll open it up to any questions that anybody has now specifically.
Awesome.
Andre, should I stop sharing the screen and go back to the?
Sure. Yeah. If you want, I can end
Okay, perfect. Yeah.
screen share here. But yeah, amazing presentation, Michael and Anu. Thanks for for walking through and sharing your insights. I was kind of writing down a bunch of things and also, just getting the nuances of how different types of incorporation can affect the business as you set it up. I agree. So I just enabled the chat. So if folks have questions, feel free to drop them in there. We also had a couple come in earlier that I can just field now. So you went over some of this, but how can buyers of existing businesses protect themselves against finding out about liabilities that weren't disclosed during the sale process?
I can answer that one. So when we talked about the purchase agreement, obviously the reps and warranties will speak to that, and they'll disclose the seller will disclose any liabilities or any existing liens. And what usually happens is that they attest to the fact that there are no liabilities affecting the assets that are being sold or the shares that are being sold. But we can also take it a step further, where in certain situations you can also have indemnity agreements, where if anything is found after the fact, then we can sign a separate agreement on the side that seller will indemnify the purchaser for any liabilities that might arise after the fact that they weren't aware of at the time. Again, legal recourse. It's These agreements are always underpinned by if they don't do what they're supposed to do under agreements, you always have the obligation to start a claim against the seller. That's the ultimate be all end all solution, to start an action against the seller. But we try and draft as much as we can to provide the most comfort to the buyer in situations like that.
And your due diligence period, which, I mean, Anu, you ran through a lot of searches and clearances that we do as, kind of standard on these things to help identify any of these liabilities that might be out there. It's certainly not to say that you absolutely need a lawyer to run your transaction, but you can just kind of see all of the things where liabilities of a business might be hiding, where they might be hiding, and a good due diligence period, structured into any sort of letter of intent. And actually, that's something that we didn't mention, but a lot of what you saw in the agreements of purchase and sale and the asset purchase agreements or share purchase agreements, they're generally going to be in a letter of intent that you do. It's a more informal understanding between the parties to be brought into effect by definitive agreements like the purchase agreements. And those things will say, if it's an asset purchase, what assets are going to form the schedules of the agreement. If there's going to be take back, on the purchase price or vendor take back things on the purchase price, your closing date, your tentative closing date at least. and your due diligence period. So giving, just kind of an understanding of what the process is going to look like, and having an understanding, a mutual understanding of that. And just to kind of, say that during that due diligence period, you want to cover as much of your own basis as you can, because you can certainly rely on the seller to a certain extent to understand all the liabilities that they have and to be forthcoming about the ones that they're aware of. But there are certain situations where they might not be aware, or they might not be aware of the extent of it for whatever reason. So there's a lot that we do on due diligence that raises points to go back to the vendor for and say, as a condition of closing, this needs to be dealt with, like what Atanu was getting into with conditions.
Yeah. All right. And then if I'm acquiring an existing business with contracts, what do I have to disclose? For example, to those contracts, that I'm a new manager or new management.
So in terms of disclose, I mean, if you're purchasing the business and you're going through the typical DD process, or the due diligence process, I mean, you have to disclose any material contracts. That's usually one of the first requests of a purchaser, is to ask for all material contracts that are applicable to the business. And you really can't withhold anything on that basis. If that request comes in from the purchaser and you decide to not disclose everything that you know of, then you are in breach, most likely, of most agreements, because you have an obligation to disclose everything that you know of. And usually these are built out in very comprehensive lists. So usually you have the agreement and then you have a schedule. So under the agreement, it will ask for disclosure of all material contracts as listed in Schedule A, which is appendix to the agreement. And when you flip to that schedule, it should list every contract or every material agreement that exists for that corporation. And anything that's not in that list, then if it exists and you don't include it, then you're in breach of the agreement.
Okay, so the disclosures are on the seller side.
Yep.
And just to follow up there in the chat from Terry, so Terry asks, is there a possibility to back out of the agreement after closure in this situation of agreements not being accurate, for example, equipment not in working order after the sale? So typically, if it's asset purchase for specific equipment, you'd include language in there that the equipment's in good working condition or good working order. And if essentially the equipment that you get is not in good working order, then that's a breach of their agreement. So it does give you recourse. Especially in an asset purchase where that's the subject of the entire agreement. So you're not kind of bound because you said you want to buy that tractor to buy that tractor if you've asked for it to be in good working condition, and they've said that by agreeing to it, and then you get it and it's missing wheels, or the engine's not working properly. You do your own due diligence on the asset itself, but they, again, like Atney said, have an obligation to disclose any issues and the current condition of it. So agreements are mutual understandings. And if something on the face of it doesn't sound like a mutual understanding, like you say, good working condition, and their definition of good working condition is that it doesn't need to be painted, but it doesn't run, then obviously that's not something that's going to be reasonably inferred in your understanding. So everything's situation specific. But if you feel like there was what we call a meeting of the minds on certain issues, and what you got isn't what you bargained for, you're not necessarily bound, beyond that.
Right. And with that, we're at the top of the hour. I think that's a good place to leave it. Again, Atnu and Michael, thank you so much for your time today. This was great content.
No problem. Looking forward to working with CSCNL a lot more on this program, and hopefully some of you as you go through the process of acquiring or selling your business. And like I said, if there's any other follow-up questions, feel free to email them either through Andre and he can pass them along, or he can connect you with us. So thanks everybody for attending. It was a great session on our end, and we were happy to be invited.
Right. Appreciate
Thank
it.
you.
Yeah, we'll share your contact info after the session with everyone.
Perfect.
All right.
Thanks.
Bye.
Have a good morning. See ya.